Okay, so it looks like we've got a really good number of participants joined us now. So let's get started. My name is Laura Elliott-Carter and I'm a solicitor in the employment team at Womble Bond Dickinson. And I'm going to be talking to you today about some of the legal issues that are presenting themselves to employers as we adapt to the government's latest guidance about living with COVID. And I'm joined by my colleague, Steve Panton. He's from our regulatory team. He's a partner in the team and he's going to be discussing COVID issues from a health and safety perspective and also looking at some stress related issues. And so something to mention from the outset is that we're in a relative state of flux at the moment. So things that we're talking to you about today may well change as the weeks and months progress, and COVID is still, as you'll be aware, a real issue at the moment. And there's been an uptick in infections and hospitalisation rates recently. I'm sure no doubt you're dealing with lots of issues yourselves in relation to COVID-19. So I'm just going to cover off some housekeeping points first of all and say thank you to you all for joining us. This is actually our first Employment Club session of 2022 and we're really grateful that you could be with us today. So this session is going to be an hour long and all your microphones are muted throughout the webinar. So if you'd like to ask us a question, you can do this with the question answer function, which is in the top right hand side of the webinar panel. If you can't see it at the moment, there'll also be 3 dots that you can press, which will then provide you with a drop-down panel in which you can access the question answer function. So all the questions will be anonymous. We're also going to provide you with a recording after the session, along with a copy of the presentation, but we won't share any delegate information when we send this out to you. We're also going to be conducting some polls to make the session a little bit more interactive for you. So you're going to be prompted when a poll becomes available and you'll have 30 seconds to respond to it. So we're actually going to get started with a poll just to get everybody warmed up. So the question we'd like you to answer should be on your screens now. And just looking at the topics that we'll be covering today, which one do you think is the most relevant to you? So we've got the employment law issues affecting employers as we adapt to living with COVID, the importance of risk assessments, the health and safety executives recently published management standards, recent cases, what's in the pipeline, or all of the above. So you've got 30 seconds to answer that question. So I'm obviously hoping that you're going to say the employment law issues. So the poll has ended now. Okay, so a lot of people are interested in the employment law issues actually. Hopefully I can answer some of the queries you have surrounding this. So let's get started. And we're going to look at first of all the issues that recent government guidance about living with COVID-19. So as you'll be aware, from the 24th of February, the legal requirement to self-isolate following a positive test was removed. And those who test positive are now advised only to stay at home and avoid contact with others for at least 5 days. The guidance now states that people shouldn't attend work and should self-isolate for 10 days, but they can return to a normal routine if they have a negative lateral flow test on day 5 or 6 or 2 later consecutive days, and that they don't have a high temperature. And something I should also add is that these dates relate to England only. Restrictions across the other nations, UK nations, are being lifted at different times in the rest of the UK. So, but what's worth considering is that the legal requirements that are being removed are similar in all parts of the UK. So hopefully it'll be applicable to people who deal with all of the UK nations. So as of the 24th of February, the legal requirement for unvaccinated close contacts to self-isolate is also being lifted, and individuals are no longer obliged to tell their employers if they're required to self-isolate and they have COVID. Then on the 24th of March, the COVID-19 SSP provisions are due to be removed, and the 3-day waiting period will be reinstated. And statutory sick pay will no longer be payable from day one if somebody is unable to work because they're ill or self-isolating due to COVID-19. People with COVID-19 will still be eligible for SSP if they meet the qualifying conditions. This is also an important date for your diaries because the SSP rebate scheme will close on the 17th of March. So SMEs will no longer be able to claim back statutory sick pay for employees' COVID-19 related absences. And employers have until the 24th of March to submit new claims or amend existing claims. Then if we move forward to look at the 1st of April, April Fool's Day, which I think is just a coincidence, the government will no longer provide free universal testing for the general public. And free symptomatic testing will, however, still be available for social care staff, and limited free symptomatic testing will be available for at-risk groups. So it appears that the advice to stay home from 5 days will be lifted from the 1st of April. However, obviously, like we said, we're in a state of flux, and whether that will change or not, we'll need to wait and see. And people with symptoms will be encouraged to exercise personal responsibility only. Employers that work with COVID-19 must continue to consider COVID-19 in their risk assessments. However, more generally, employers aren't required to explicitly consider COVID in risk assessments. So the Business, Energy and Industrial Strategy Government Department, BEIS, set out their Working Safely guidance. And this is due to be replaced with new public health guidance, which hasn't actually been published yet. But we did attend a meeting with BEIS earlier this week, and we understand from them that the guidance has been drafted and is currently with ministers for comment. But it's likely to say that people should stay away from the workplace if they have symptoms. Separately, BEIS is carrying out an informal consultation with businesses at the moment on whether there should be separate guidance for employers, and if so, what it should contain. And that consultation is actually open until 5 p.m. today if anybody wanted to quickly submit any responses to it. So in addition to these dates, the requirement for social care and frontline NHS staff to be vaccinated is being revoked with effect from the 15th of March. And that means that staff who've previously been dismissed in the social care sector for not being vaccinated could be offered their old jobs back, but it does mean that they won't get their continuous employment continued. Employers are also advised to encourage staff to continue to be vaccinated. So we're going to move on to look at some employment issues. I've got a series of questions for you, and these are all questions that have been put to us in the employment team recently. So hopefully they'll be of practical use to you too. So the first question is, can you require employees to return to the workplace? So as you've probably come up against, there are many difficult issues to be considered here. And the first is whether you are going to require all workers to return. If you have any employees that haven't been vaccinated, or immunosuppressed, or at high risk from COVID, or they might live with somebody who's high risk, then you need to think about whether they need to return or whether they can work from home, as especially with the increase in infections, they're now probably more likely to catch COVID-19 now than at any time in the past couple of years. You also need to consider whether you require all staff to return or whether you're going to make any exceptions for disabled employees. There is the risk of facing disability discrimination claims if you don't consider disabled employees as a separate group, and they could claim that being subjected to a detriment because of their disability or because you failed to make some reasonable adjustments for them. You might be likely to find you get mixed responses from employees. Some will be keen to return and some will want to carry on working from home, and others will want to continue with some kind of hybrid working. You might also find issues around travelling. Some employees might be concerned about getting on public transport. I did note that yesterday the Scottish government decided that they're going to keep in place their mask wearing restrictions until the 1st of April, when it would be reviewed again. So where employees do have some genuine concerns, the best approach is to speak to them, see if you can reassure them, and for example, come to some kind of workaround, even if that's only temporary. For example, could you work with them so that they can travel outside of rush hour, for example, or perhaps help them facilitate driving into work? Another consideration is whether it would be helpful to have a staggered approach to getting people back into the workplace. It might be helpful to consider asking them to return for 1 day a week in the first month back, 2 days a week in the second month back, etc. This gives them an opportunity to plan, get used to the idea of being back in the workplace. And it also gives them time to sort out some of the personal practicalities, such as who's going to do the school run and who's going to look after the lockdown dog. There's also some tricky issues that might arise if employees refuse point blank to return. We've been hearing of some employees trying to attach conditions to their return. For example, I'll only come back if you pay my travelling cost, or I'll only come back if everybody's vaccinated. And some employees might try to say that their place of work has changed from the workplace to their home by custom and practice, and that they should now be able to claim expenses for going into work. So there will obviously be a range of reactions from the employers to this, and some people might take a fairly hardline approach, but there's obviously a lot of job vacancies out there, so I think there are some employers that might be taking a softer approach because they don't want to lose employees to other businesses. So if you decide that you're going to continue with a remote or hybrid working arrangement for some or all of your employees, it is likely that the contract of employment will have changed and the place of work within that contract will have changed. So this means that giving a statement of particulars of the change will need to be given to any relevant employees at the earliest opportunity, and in any event, no later than 1 month after the change. If you have any disputes with employees, and I know that some of you probably have had this so far, the best practice is to deal with these disputes carefully, and any genuine concerns need to be taken seriously. So it doesn't mean that employees will be allowed to refuse to return without any good reason, but we do think that employment tribunals are going to have some sympathy with the notion that the pandemic has shown many roles can be performed from home and be performed well from home or on a hybrid basis. And if employers do wish to return their workforces to the workplace, it's going to be really important to do this through consultation, perhaps via staff surveys, or if applicable, consulting trade unions. I know that some of you, again, have been through this already, but if anybody wanted any advice or assistance on this point, then we would be happy to help. So we're going to move on to the second question in this section. How do you deal with flexible working requests? So any employees that are required to return to work, having worked from home during the past couple of years, might decide to submit a flexible working request to change their place of work. And if they have more than 26 weeks employment, then they can do this. These requests will need to be handled carefully too, and employees might argue that they've already demonstrated that they can successfully work from home, so the request should be granted. And as we've said, the Employment Tribunal is likely to be sympathetic to that viewpoint, and employers therefore need to have quite a clear explanation as to why the employee's role requires a physical presence. In any event, if an employee's request is refused for one of the 8 business reasons, such as the burden of additional costs or the quality of work will suffer, etc., then the employee might find another job that is more flexible. And I'm sure you've all heard of this period of time being described as the Great Resignation period. However, employers are entitled to rely on the fact that the pandemic was an extraordinary event and that they had no choice but to comply with legal restrictions in place at the time, which required everybody to work from home where possible. And that period of time is now over, for the time being at least, and they need to get employees back to the workplace if indeed their presence is definitely required in the workplace. So where an employee is disabled under the Equality Act 2010, you need to consider whether you need to make any reasonable adjustments to, and an employee who's at high risk of COVID-19 may well be disabled, and it would be difficult to argue that working from home is not a reasonable adjustment if a role has been performed at home without any issues for the past 2 years. If we look at our final question on this slide, and then move on to our next set of questions, can you require employees to do a lateral flow test? So as we've discussed, free tests are being withdrawn from the 1st of April, and lateral flow tests are going to be available to buy from retailers. I think large pharmacies are indicating that they're going to charge around £2 per test. So you'll need to consider whether you're going to require employees to test themselves before coming into the workplace. Alternatively, you might decide only to ask employees with symptoms of COVID-19 to take a test. And if testing is required, you need to look at whether you're going to supply those tests or reimburse the employee for taking them, buying them, subject to any tax rules. And obviously there's going to be a cost consideration, especially if you have a large workforce. But conversely, it is important to think about what the repercussions might be if you don't assist employees with the cost of testing, because it would mean fewer employees will take the tests, and any testing policy that you do have in place might be ineffective in reducing the risk of workplace outbreaks. It would be important to consult with trade unions from a health and safety perspective, or any employee reps or the employees themselves before introducing a compulsory testing policy. And again, if you'd like any help with any of those policies, one of our team would be very happy to help with that. So we're going to move on to our next slide, next set of questions, and we have another poll for you. So the next question is, do you require employees to stay at home if they test positive or have symptoms of COVID-19? So yes, no, or don't know. So you have 30 seconds to answer this question. And as we said, the results will be anonymised. Okay, still got a couple more seconds to send through those answers. And the poll's ended now, thank you. So yeah, that's really interesting actually. So the majority of people, 82%, do require people to stay at home. It's actually quite a topical matter as well, because you may well have seen in the press yesterday that Wilkinson's or Wilco's had to do a U-turn on this particular issue, because they had said that employees with COVID should still continue to go into work. So as we know from the 24th of February, somebody who does test positive is actually no longer legally required to self-isolate, but they are encouraged to stay at home for at least 5 days. So you do need to consider your policy on self-isolation too. You need to look at whether you'll be requiring employees with COVID-19 to remain at home in order to stop the spread of the virus at work. And if employees who test positive come into work and infect others who become ill, then this could cause some real issues, as we said, for resourcing, as well as presenting issues with other colleagues. Employees who test positive may well be unwell and go off sick anyway. Symptoms might want to continue going into work, perhaps for financial reasons, and this will present more difficulties. If you decide that you require employees to stay at home, you'll need to think about the pay implications, bearing in mind that SSP will no longer be payable from day one. And there's almost a bit of a discrepancy here between the behaviours that the government want to see with the new guidance and the SSP system. So there's almost a bit of a burden on employers in this respect. So where you require employees to stay at home, you should pay them, otherwise there is an incentive for them to come into work, and obviously then the risk of spreading the virus. So if an employee can work from home, they should do so on normal pay. If someone is ill, you should pay them company sick pay or SSP as appropriate. And where they don't qualify for company sick pay, perhaps because they're on a probation period or they've used up all their entitlement, and the best policy would be to pay in full in order to encourage employees to stay at home and not spread the virus in the workplace. Where somebody has no symptoms of COVID, then you should treat this as a medical suspension or health and safety suspension and pay full pay if the person cannot work from home. This may mean that you have to pay full pay to everybody who tests positive and can't work in order to avoid grievances and any possible discrimination issues too. However, you might not know that employees tested positive because they now don't need to tell you as of the 24th of February, like we said. And once free tests are discontinued, it's going to be a lot more difficult for the employee to know whether they have COVID-19 or not. And self-isolation also presents some other difficult issues, such as whether employers will need to leave themselves open to claims by employees if they don't require somebody who's tested positive to remain at home. The best approach is to have a clear policy on what your approach will be to self-isolation and pay. But overall, we think that perhaps encouraging employees who've tested positive to remain at home must still be the best policy, but will only work if you're willing to pay sick pay to those who do. And such a policy is going to be much more effective if you pay company sick pay rather than SSP. So we'll move on to our next question now. Can you enforce a mandatory vaccination policy? So given the fact that the compulsory vaccination for care workers and frontline NHS staff was revoked as of yesterday, it's now going to be much more difficult for other employers to enforce. You're going to need to really be able to justify any policy that deals with that and consider whether you're going to make any exceptions, but then you run the risk of making yourself open to discrimination claims. You might find that an employee might object to working near somebody who hasn't been vaccinated or who's known to be anti-vaccination, and they could bring a grievance if this isn't resolved. And given the difficulties of enforcing compulsory vaccination, such grievances are likely to raise legal issues if the employee concerned is disabled or at a higher risk of COVID-19. So we'll look at the final question in this section now, and I'll pass over to Steve. So do you need to continue with health and safety measures in the workplace? So as we said, in some of the nations, face coverings are no longer legally required, although current government guidance is to wear them in crowded and enclosed spaces where you might come into contact with other people that you don't normally meet. So you might want to consider whether you still require people to wear face coverings in all areas in the office, for example, or certain communal areas, or whether you're going to continue with other health and safety measures such as providing hand sanitizer, regular cleaning of surfaces, booking desks in advance and social distancing. And you should continue to follow the working safely guidance until the 1st of April, like we said. The new public health guidance will apply as of then. When the new guidance is published, you should review it and decide what steps you need to take in order to comply with it. And so in summary, we suggest that on all of these issues, you need to decide what your policy is going to be if you haven't already done so. I'm sure some of you have already set the wheels in motion with these policies. And then you'll need to communicate it to staff so that everybody's clear about what to expect. And you might just need to update the policies as and when new guidance is published or amended. And like with all of these things, if you want any help with the policy drafting or advice on any issues that present themselves, then we would be happy to help. So I'm now going to pass over to Steve. I think he's going to have another poll for you.
I will. Thank you very much, Laura. Yes, we do have a poll. It's a little later on, but I'll come on to that in a moment. Over the course of the next 15 minutes or so, I was going to speak about managing risks to employee health and safety in the post-COVID workplace. As we move out of the pandemic and easing of restrictions, that the challenge for business is making sure that it is properly positioned and has adapted to the new working environment that has developed. I'm going to be touching on managing the risks of transmission of coronavirus in the workplace, also looking at those wider workplace and work-related risks post-COVID that need to be carefully managed, and also end with a particular topic area, which is managing health and well-being risks and making sure that your business is properly equipped to address and control those risks, and also looking at HSE's management standards on stress. As you'll have heard from Laura, the position that we're currently in, 24th of February 2022, the legal requirement to self-isolate following a positive COVID test has been removed. And come the 1st of April 2022, the legal requirement on employers to specifically consider COVID-19 in workplace risk assessments will also be removed. But really, what should employers do from the 1st of April 2022? That's already been highlighted by Laura, and also through the poll, that the majority of organisations are recognising, as they should do, that whilst the specific legal requirements that have been in place for the last 2 years regarding control of COVID-19 transmission within the workplace, there is and remains that general duty on employers under the Health and Safety Work Act to ensure, so far as is reasonably practicable, the health, safety and welfare of their employees. And given the current material and significant continued transmission rates, that risk of transmission of coronavirus in the workplace is a real risk. And as such, businesses are very much encouraging to follow the guidance that's in place by HSE and other government departments, which essentially is maintaining those risk assessments and controlling COVID-related risks, even if the standalone COVID-related workplace assessment is no longer being progressed. The principles and the controls and measures should be. So it's really continuing to tell employees with COVID-19, where they've confirmed or suspected diagnosis, to stay away from the office and work from home when they can, to maintain adequate ventilation and cleaning. We have a date of the 1st of April 2022 does not mean that the virus will go away overnight. Considering the use of face coverings in crowded or enclosed spaces, where people and employees may come into contact with others that they don't normally meet, and also importantly, to continue to consult with staff and ensure that the policy and the controls and measures that they are required to continue with are properly communicated, and where necessary, training is given. So, as Laura said, we are in a state of flux, and the message really is to watch this space. Between now and the 1st of April, in England, Wales, Scotland and Northern Ireland, there is the potential for the administrations to issue central guidance, and also for HSE to publish revised guidance. So we really will just have to wait and see. As Laura said, we've got the BAYS consultation, which finishes at 5 p.m. today, if anyone's interested, on the future approach that businesses would like to be taken in managing COVID-related workplace risks. Ultimately, the decision for government will be, do they require employers to adopt general public health guidance that's available, leaving particular controls and measures to the discretion of employers to decide their own approach, or to introduce its own guidance specifically for employers. We would just have to wait and find out. But one key date that you might be interested in, and your health and safety colleagues, is that HSE will review its COVID-related guidance on or before the 23rd of March 2022. So it'd be useful just to have a look to see what, if any, guidance has changed. Just looking at some wider non-related COVID risks in the workplace, given that we are undoubtedly, for most companies, emerging with new workplaces and working arrangements, risk assessments and the importance of these, I think, is no greater at any time since the requirement for work-related risk assessments to be brought in under the Management of Health and Safety Work regulations in the late 1990s. Risk assessments underpin the health and safety management of your organisation by identifying the risks, having those controls and measures in place. But an important part of your management of risk processes is not only ensuring that your risk assessments are valid, they're still suitable and sufficient, and have been varied to change in your working arrangements, but also key to have those policies and procedures and controls in place. A critical part of that is making sure that those team leaders, line managers know what they're supposed to be doing, and also importantly, given the rise in hybrid and remote working, that there are proper lines of engagement to all team members, and that is a consistent approach that's taken by line managers because they are the business's first line of defence when looking at employee well-being and whether or not they are carrying out their roles in a safe and suitable manner. Lone working and home working, again, it's an obvious one. There is guidance publicly available, particularly on HSE's website. There are a range of consequences and risks from that hybrid and home working environment, display screen equipment, but also that well-being piece, which I will come on to several times, around lone working. Another one that is on the rise, and I foresee to be a growing focus with HSE, is around the management of work-related fatigue. Given, I think without doubt, the home working environment and the technology that's available, that the people and employees have been putting in significant working days because they don't have their work-related travel to take into account. And there's a case that came out that sentenced in March 2020, which really went under the radar of many businesses, given that we were just in the grip of the pandemic at the time. It's a case of renowned consultants. They were sentenced following conviction in March 2020 and received a fine of £450,000 for failing to manage worker fatigue. This was an engineering consultancy company that often did last-minute, overnight engineering support service work in the rail sector. They had 2 employees that had left home early in the morning, the previous morning, undertaken a full night shift, and as they were coming back to their depot the following afternoon, an urgent job that night came in. They were informed that they would be doing it. They were told to go back to the depot because there wasn't time to go home, to effectively rest for an hour or two before setting off for several hours to this new project. They then waited around for several hours, and due to an earlier phase of that work overrunning, they weren't actually required to work on that project overnight. So in the early hours of the morning, they were stood down and travelled back several hours again to their home addresses and depot. And on the way home, sadly, the colleague that was driving fell asleep, and that led to a fatal road traffic accident, which he and his passenger employee colleague were both killed. And in that case, the company had recognised and identified the risk of fatigue. They had policies and procedures in place, but they did not act on those policies and procedures. So a couple of messages there is look at worker fatigue. Is it a risk that impacts or potential to impact on your employees? And if so, to really think about what practical steps you need and should be undertaking and implementing. Some other areas, again, I'll come on to stress, mental health and well-being in a few moments, but really a key message is making sure that your HR, your health, safety and compliance teams and occupational health are all joined up, not only in making sure that everything is in place, that those controls and measures are being monitored, but also to ensure a consistent approach to compliance and making sure that employees are doing what they're meant to be doing and that any enforcement action is consistent. So that real joined up message. So before I move on to the next slide, I think we might have our next slide. I don't know if we can pop this up. Here we go. Question is, what percentage of new and long-standing cases of employee ill health are attributed to stress, depression and anxiety. Again, you've got 30 seconds and you've got the options in front of you. That is it. And 60% of you are absolutely right. Recent HT statistics have revealed that 50% of new and long-standing cases of stress, depression, and anxiety are due to ill health and absence from work. So that is a real risk. It is going to be a significant risk for many organisations and one that simply can't be ignored. Final subject, just looking at managing stress, mental health and well-being. I know there's been a lot of publicity and raising of this particular issue, but I'll just give you a summary of my thoughts and recent developments. HSE have stated for several years that it is a long-stated aim of an increased focus on occupational health and occupational disease, and not in any way diminishing the lost time and employee illness rates due to traditional accidents and incidents. Occupational health is a topic area and a focus area of HSE that will not go away. HSE's expectations are that employers are taking a proactive rather than reactive stance to managing work-related stress through the management standards, which have been recently refreshed and updated. And if organisations don't fully adopt those management standards, to be seen to be adopting an approach similar to those in terms of having suitable risk assessment methodologies in place to really manage work-related stress. HSE also want to see more HR and health and safety professionals trained and competent in implementing the management standards or the principles of those within the organisation, and also for cross-sector learning about what works in other businesses within your sector and elsewhere, to see whether they can be built into your systems and controls. So very briefly, what I would do, encourage you when you have a minute, or your health and safety colleagues, is to really just have a look at the management standards if they're not in use within your organisation on HSE's website. But essentially, the stress management standards represent a set of conditions that, if present, demonstrate good practice via a 5-step risk assessment process that will not be unfamiliar to your colleagues. And as with any HSE guidance, when there is a suspected failing or breach, HSE will look to see what guidance is there that's publicly available, and to really benchmark and look at how an organisation is meeting its obligations and implementing that guidance. The stress management standards highlight several key areas of work design, which is around demands, control, support, relationships, the role of the individual, and also managing change, requiring employers to identify the risks in the usual way, identify who can be harmed and how, to evaluate and assess those risks, to record the findings of that risk assessment review, to make sure that the controls and measures are in place, and importantly, not to stop, but to make sure that there is an ongoing monitoring review as to the adequacy of those arrangements. Finally, some food for thought in terms of managing stress. A few key dates that I picked out. October 2019, HSE published guidance on when they will investigate work-related stress and how organisations manage those risks. Really sets out the benchmark as to when HSE can and will commence a formal investigation with a view to potential enforcement action. And really building upon that announcement, October 2021, HSE announced that spot checks of business and organisations will also now specifically cover work-related stress, so that in every sector that HSE are responsible for enforcing, that is an issue that will now be focused on, and really to flag up with you that the need to make sure to spend the time to make sure that you've got the adequate, suitable, sufficient arrangements in place. And also in October 2021, an improvement notice was served on the University of East London for failing to manage the risks of work-related stress amongst its employees. Very little is known about the case. The outcome is not known, and therefore there has been a probable appeal of that notice, leading to or separate from any withdrawal of the notice. But the message to get across is that is an obvious sign of HSE's intent to take enforcement action where they think it's necessary. And again, just building on and complementing the stress management standards, in late January 2022, HSE released an expanded version of its stress indicator tool, version 2.0, to really take account of the significant changes to working practices, technological innovations that have altered the way in which people work. And again, that is well worth a look for a few minutes online. If you've got employees for up to 50 employees, that toolkit is free, and then there is an immediate and an annual charge depending on the number of employees you've got. But it's really that the toolkit is a form of survey that you can run throughout your business to really strength test your roles and measures, but also to identify, are there any pockets or teams where there may be a need for a focus. So that is everything from me. I will pass you back over to Laura.
Thank you, Steve. That's been really helpful. Obviously, lots of the health and safety issues, particularly the stress issues, go hand in hand with some of the issues that people in HR and some of our legal contacts will be dealing with at the moment. So it's really helpful to have your insight on those issues. So I'm going to look next at recent cases and what's in the pipeline. And the first case we're going to look at is the case of Smith and Pimlico Plumbers, which many of you have probably heard about or potentially know about already, because it is a really important case. So I think it's worth us going through it today too. So the question that the Court of Appeal recently looked at was, can a worker carry over until termination of their engagement any leave which has been taken but not paid because the employer didn't recognise that he was a worker? So the background to this is that employees and workers are entitled to a minimum of 5.6 weeks paid leave each year under the working time regulations. An individual who provides services to an organisation as a genuinely self-employed person is not entitled to paid holiday. So the facts of this case were that Mr. Smith worked for Pimlico as a plumbing and heating engineer for nearly 6 years. Pimlico maintained throughout that he was not a worker within the scope of the working time regulations, so he wasn't entitled to paid annual leave, and they treated him as self-employed. Mr. Smith did routinely take unpaid leave, unpaid holiday at Christmas, during summer holidays and on bank holidays, but he wasn't paid any holiday pay. When he left Pimlico, he brought employment tribunal claims for holiday pay under the working time regulations and unauthorised deductions from wages, and he sought to recover the unpaid holiday pay that he had accrued throughout his engagement. Pimlico challenged his employment status, and the Supreme Court ruled in 2018 that he was a worker, so he was entitled to holiday pay. And again, many of you will remember that case because it's had some real significant impact on employers. And more recently, Mr. Smith's holiday pay claim then returned to the Employment Tribunal. So the decision in this particular more recent case is that the Court of Appeal found in Mr. Smith's favour after his claim had failed at both the Employment Tribunal and the Employment Appeals Tribunal. The Court of Appeal decided that a worker can carry over a right to payment for annual leave from 1 year to the next if he or she has been permitted to take annual leave but was not paid for it. And the right to the payment doesn't lapse, but it carries forward year on year and accumulates until the termination of the engagement. And what the Court of Appeal said is a single composite right to paid annual leave. So what that means is that if a worker takes unpaid leave when his employer disputes the right and refuses to pay for the leave, the employer is almost putting certain preconditions on this right, and the worker's not exercising that right. So it meant that Mr. Smith was entitled to payment for almost 6 years' worth of holiday. And the case has now gone back to the Employment Tribunal for them to award his compensation. So what does this mean for employers? So the decision has some quite significant implications for holiday pay and really raises the stakes for businesses facing employment status disputes. It's now much easier for workers to bring holiday pay claims, and this means practically that you should be looking carefully at anyone you might treat as self-employed, because in reality, if they're an employee or a worker, then they'll accrue the right to paid holiday throughout the whole of the time they're engaged with the employer or with you. So you could be faced with a substantial claim at the end. So, for example, if a worker is treated as self-employed for 12 years and takes 4 weeks unpaid leave each year or doesn't take any leave at all, he'll then be entitled to 48 weeks pay on termination. In Mr. Smith's case, this was quite a substantial £74,000 that he could be receiving. But it's worth noting that this only applies to the 4 weeks leave in the Working Time Directive and not the 1.6 weeks additional leave provided under the Working Time Regulations. It should be subject to a 2-year backstop. So, what does this mean and what steps might you need to take? So it's going to be really important to be transparent with workers and encourage them to take paid annual leave, and also inform workers that the right might be lost at the end of each year. And in that case, in those cases, the Court of Appeal said that a worker can perhaps lose the right to take leave at the end of each year. So I think we've got time just to look at our second case. It might be a whistle-stop tour of that one. So the case is Hope and British Medical Association. And the question that the Employment Appeals Tribunal looked at was a case for gross misconduct fair when it related to raising numerous frivolous and vexatious grievances? So the background to this is, as many will know, for a dismissal to be fair, it must be for one of the 5 potentially fair reasons in the Employment Rights Act. And those 5 reasons are conduct, capability, redundancy, breach of a statutory restriction, or some other substantial reason. An employer must follow a fair procedure, and the decision to dismiss must be within the range of reasonable responses open to an employer in the circumstances. So this is actually a really interesting case, and the facts of it were that Mr. Hope was employed by the BMA as a senior policy advisor. He brought a number of grievances against senior managers which concerned matters such as their failure to include him in meetings that he thought he should be attending, and he wanted to discuss these grievances informally with his manager. However, the issue was that the line manager felt he couldn't resolve the issues because they concerned decisions that had been made by more senior colleagues or more senior managers within the BMA. So Mr. Hope refused to progress any of his grievances to the formal stage, but he also refused to withdraw them. So he was warned that continuing to raise the grievances could result in disciplinary action, and a formal grievance meeting was arranged. He was told that if he refused to attend, that it would be deemed as a failure to take on board a reasonable instruction. So the meeting went without him and his grievances were not upheld. The BMA found the grievances to be frivolous, vexatious, disrespectful and insubordinate, and he also said that he had failed to comply with a reasonable management instruction to attend the meeting, and that amounted to gross misconduct. It took disciplinary action against Mr. Hope and then ultimately dismissed him for gross misconduct, and he went on to claim unfair dismissal. So the decision in the EAT was that the dismissal was fair and that the employer was entitled to find that the grievances constituted gross misconduct in the circumstances where the employee refuse to progress or withdraw them and refuse to attend a grievance meeting, despite being told that it was a reasonable management instruction to do so. And the Employment Tribunal had also been entitled to find that the employer had acted reasonably in treating the reason for his dismissal as being sufficient reason to dismiss him in all the circumstances. So what does this mean for employers? What does this mean for you? So it is actually a really helpful case. I know that lots of you have faced situations where you receive numerous grievances from employees. In fact, we've helped some of you and advised you on some of those issues. However, what was key here is, and key to the finding of their decision of a fair dismissal, was that the BMA had found the grievances to be frivolous and vexatious. So it would be really important for any managers hearing grievances to be clear in their findings on this point. And particular care would need to be taken if a grievance related to a protected disclosure, in which case the employee would be protected by whistleblowing legislation, or if the grievance contained any allegations of discrimination. So I'll briefly pick up on a couple of points that are in the pipeline for the next 6 months and what's on the horizon in the employment law world. So as of the 1st of April, new hourly rates will apply to the national living wage and the national minimum wage, and also statutory sick pay, statutory maternity pay, and other statutory family payments are due to rise at the beginning of April. However, the amounts of these increases and the date from which they're due to take effect haven't been announced, but we will obviously let you know when we hear more on that. And another key point just to highlight to you is that the government has said it will introduce new visas in the spring, including an elite points-based visa, a global business mobility visa, a scale-up visa, and a high potential individual visa. So if you need any advice on these, please do get in touch with one of our business immigration lawyers who'd be happy to help with any queries. So I think we do have time to run through a couple of questions, and thank you to those of you that submitted questions beforehand. And it's really helpful to have some practical examples to work through with you, and hopefully it will help other participants too. So have a look at a couple that have come through today too. So first one, which I think a lot of people want to know the answer to, is how can we effectively deal with reluctant returners who don't wish to come back into the office? So assuming that you need them to come into the office, that they can't continue to work from home, then what we would suggest is asking their line manager to speak to them and find out why they're reluctant to return. For example, is there a genuine reason? What can you do to help them in order to return? Is there any kind of compromise possible? If the reason isn't genuine, then perhaps you could ask them to return on a particular date and state that this is a reasonable management request. If they fail to comply with this, then you could consider taking disciplinary action against them. And this should obviously be put in writing so that you have an all-important paper trail. And then you'd need to obviously hold a disciplinary hearing with them if they failed to return without good cause. I think we also have a query for you, Steve, from a health and safety perspective. And
I think there are a couple. First of all, probably deal with the discrete one. A delegate has asked for details of the case I mentioned regarding worker fatigue and fatigue management. The case or the defendant is a company called Renown, RENOWN Consultants, and it was a prosecution brought by the Office of Road and Rail. So hopefully that answers that question. And I think the other one was following guidance. It is a best practice approach due to the general duty of care owed to employees and others. In answer to that question, the answer is yes, that the general duties qualified by reasonable practicability. You've got to do what a reasonable employer in your circumstances would do. And when there's guidance that's there, whilst you don't have to adopt each and every part of that guidance, when benchmarking the adequacy of your controls, and particularly if something's gone wrong, you know, the regulator, HSE, will have regard to that guidance and really ask itself and the organisation the question of, is it reasonably practicable for you to have adopted that guidance? And if not, why not? So hopefully that answers that question.
Great. Thanks very much, Steve. So we have another employment law related question, which is around managing people working in an office, and the employer decided to say that if employees have a close contact who is testing positive for COVID, they're asking their employees to remain at home because they don't want them to come in and transmit the virus. Some staff don't like this, apparently for well-being reasons, but the organisation is trying to protect all staff. And they just want to know whether they can legally require them to work from home. So the answer to this is that you can if you have a clear policy in place, which ideally you would have consulted the employees on and which all staff are aware of, and then you can ask them to work from home. Potentially one difficulty you might come up against is if you have a disabled employee or somebody who would be classed as disabled under the Equality Act because they have a mental impairment, and they might argue that their mental health would be adversely affected by working from home. In which case you then need to consider whether coming into the office would be a suitable, reasonable adjustment for them. Or you could perhaps look at some alternatives, like asking them to take a daily lateral flow test and only come into the office if it's negative. So I think we might have time for another couple of questions, which is brilliant. So this is a really good question, actually. Can we ask prospective employees at interviews if they have been vaccinated? Or can we turn down a candidate because they haven't been vaccinated? So a compulsory vaccination policy is becoming a lot more difficult now because, like we said, because of the social care compulsory vaccination policy being revoked in the social care sector and the NHS. So you could probably only justify it if you had a special reason for it, such as the prospective employee would be working with vulnerable people, and you might still be open to discrimination claims by prospective employees if they have a protected characteristic, and that was the reason for not being vaccinated. And also, in addition to this, it's important to consider whether there are any data protection issues around asking candidates for information about their vaccination status, as this is a special category health data. Steve, we also have another question for you about what organisations are most at risk of being subject to enforcement action by HSE for failing to manage work-related stress.
Thanks, Laura. Yeah, in the time available, I've probably flagged up, in my view, what is one of the most focused sectors, and that's really public organisations and bodies, universities, healthcare trusts, potentially schools. That's where I see, as and when HSE do consider there's sufficient evidence to take enforcement action, which I think will probably in the form of an improvement notice, that they will probably look to those public sector organisations in the first instance. But again, those businesses where there is evidence of multiple employees, their work-related risks in terms of stress, mental health and well-being not being managed, then there will come a time when HSE will take enforcement action where there is a significant and widespread failure to manage work-related stress risks within a private organisation. Don't know when that will happen, but I think the time will come at some point for it.
Great. Thank you very much. So I think that's all we've got time for today. So thank you to everybody that's joined us. We have covered a lot of information, rattled through it at times. So if you do have any follow-up questions, then our details are on the presentation now. So please do get in touch. There's also a quick questionnaire for you to complete when you leave the webinar. I'd be really grateful if you could complete that because it helps us to inform later employment clubs for you and make them as interesting as they can be for you. And the results of those will be anonymous too. So thanks again, everybody. Enjoy the rest of your days. Thank you.
Thank you.